Let's here with another video on high conflict child custody. This video is going to be titled Modifying Physical Custody, which I know is probably one of the biggest things people want some information on. The thing that is really frustrating is modifying physical custody is a lot harder than setting it up in the first place. And I think I've mentioned this before a few times. So I just want to remind everyone right from the beginning. At the beginning of your case, before you have your decree or your judgment, is when you really need to focus on this and look at it and think carefully. A lot of people settle and come to agreements that later on they need to modify for whatever reason, and it's just so much harder to modify physical custody once an order is already in place. I've heard rumors, I don't know if this is true or not, but I've heard rumors that some judges might modify a physical custody relationship once in their entire career. I don't know if that's true or not, but from my experience of how much evidence and how much of a push I needed in my case, I'm inclined to believe it. So what triggered this video, even though I've been thinking about doing this for a while, is a comment from David Smith. In my previous video, the Best Interest of the Child Factors video, where he asked me well, I'm going to let you guys read his comment if you want on here. I'm not going to read it verbatim, but the gist of it was, when is enough? I mean, when can you say I have enough now to modify physical custody? And obviously there's no formulaic answer to that. There's nothing specific that I can tell you because based on my best interest factors, there's I can't even remember now, 10 or 11 different factors, and of course, judges have different personalities and perceptions as to what they think is enough. I did mention you can sometimes get their decisions reversed, but because best interest requires so much fact-finding, if you've taken a look at my video on appeals, you would know now that modifying or disturbing the facts on appeal is not as easy as disturbing the legal conclusions of the judge. So, because there are so many factors that go into best interest of the child, and because those factors are so heavily dependent on fact-finding, and because appealing the findings of fact of a district judge is a lot harder to do than appealing the conclusions of law, it really is a fuzzy issue as to when you have enough to actually modify physical custody in your case. But what I can do is I can show you how I did it using my case and my specifics, and hopefully you can draw analogies from what happened in my case to what's going on in your case. So with that, I'm going to get right into it. In my case, I modified physical custody on subsections D, E, and G of Nevada Revised Statute 125C.0035, subsection 4. Which I mentioned in my previous video. It's a lot of numbers, but all that is this long list of best interest of the child factors. Subsections D, E, and G are the level of conflict between the parents, that's D, the ability of the parents to cooperate to meet the needs of the child, that's E, and the physical, developmental, and emotional needs of the child, that's G. I'm going to go into detail now. So what the court did in my case is I started out with at this point I had joint physical custody, and the court modified it such that it severed the joint physical custody relationship, awarded me primary physical custody, and gave my ex visitation rights. Now remember, this is at a point in time. Currently my ex's parental rights have been terminated. But I'm just going to talk about this right now so that people can look at what happened in my case and draw analogies towards what's going on in their own cases. So, in citing those subsections to modify physical custody, the court made findings of dental neglect, absences regarding taking our son to school, and what it focused on was testimony from a dentist. So I actually got my son's dentist to come in, testimony from a dental hygienist who was in Las Vegas at the time. I live in Henderson now, but at the time of this hearing I was in Reno, so the dental hygienist had to testify telephonically. And repetitive efforts to frustrate my rights to go to medical appointments, vision appointments, dental appointments. I'm gonna break these down even more, so just hang in there. The emails that we sent back and forth, the court analyzed those emails. And one last thing that was big, the midnight exchanges, which I'm going to go into detail as well. So Now that I've given you kind of the overarching, that's a lot of information for you people. If you need to watch this again and again to get it really drilled down, feel free to do that. Now I'll go into the details. So here was the situation regarding how I established that dental neglect was a problem, and that it was a problem because my ex took active steps to frustrate our son's need to get um, dental care. He needed 5 crowns and 2 extractions. So I needed to prove 2 things. The first thing I needed to prove is, obviously, he needed 5 crowns and 2 extractions because his teeth were in bad shape. The second thing I needed to prove was, this wasn't my fault at all, not even half. Like, you can't go to court and say, our son has dental problems because of both of our faults, give me custody. That doesn't work. You have to show, number one, there's a problem. It's affecting the best interests of your child, and it's entirely the other parent's fault. And this is hard to do. You can't go into court and try things like, I've seen people try this. Well, now that the father's involved, all of a sudden our son's teeth are decaying. Or now that mom's involved, now all of a sudden our son's doing bad in school. The court can't use that. The court can't say, oh, look, because all of a sudden one parent's involved, I'm going to assume that that parent is at fault for everything that's going on. That's not true. What I had to do in my case was show, I had to actually get these things called red coat tests, which is something that they put on your children's teeth to test how much plaque is there. And what I would do is I would pick him up. As soon as I picked him up from the exchange from my ex, I took him straight to the dentist. And I did the red coat tests in the dentist's office. The hygienist did the tests, and the dentist looked at them. And what this allowed the hygienist and the dentist to come into court and testify. Some people might say, oh, well, can't you do the test yourself? Well, if I do the test myself, what's my ex's attorney going to say? She's going to say, he did them on his own time, and that represents dad's inability to brush teeth, not mom's. And how am I going to fight that? I'm going to have to fight that with my own testimony, which is always taken with a grain of salt. I wanted to set the situation up where I need evidence to show that this is happening on her time, so I need to get this tested as soon as I pick him up, and I need to get this tested by someone who's not me, because their testimony is going to have some weight behind it. So when it went to court and the dentist and the hygienist testified, they were able to say that I was there, I did the test, and this was bad. He hadn't brushed his teeth for days. This is the way that I was able to show 3 different examples as to when he had the red coat test done in the dentist's office. And those 3 different examples were enough for the court to say that mom is consistently not brushing his teeth at all. We're not talking once a day. We're talking at all. Like, for all those days in a row, no brushing was going on. So this is what allowed me to show the court his teeth aren't being brushed. The consequence. So you can go into court and you can say that there's a potential for damage. And my experience was with my 2 judges, it just wasn't strong enough. Judges don't like to modify physical custody. So in my case, I wanted to show, and this sucks because your son or daughter has to suffer before you can actually get any relief. But I wanted to show, number 1, this is the conduct. Number 2, this is the consequence, and it's happened now. The damage has already been caused. And number 3, it's entirely the other parent's fault. And this is the number 3 is the hardest. A lot of people can show that there is conduct, and a lot of people can show that there is damage, but very few people can show that it's the other parent's fault entirely. Because the courts aren't inclined to do that. They aren't inclined to want to place blame. A lot of courts want the children to be with both parents, which is good to start out at, it's a good default position. But if you're going to say that the other parent is the one that's entirely at fault, you have to prove it. And you have to prove it convincingly. So the dental damage was obviously the strongest evidence that I had to modify physical custody. One of the other things that I was able to get the dentist to argue, or the dentist to testify to, was that there was no way to really retain the joint physical custody relationship without our son's teeth continuing to basically rot. The court was going to have to modify physical custody so that our son would be in my care primarily, because it was physically impossible for me to somehow pick up all of the burden on that and keep his teeth healthy. It just can't. The dentist testified, you can't just skip 2 or 3 days in a row and have the other parent brush more often and sort of make up for it. It just doesn't work. And that testimony was critical because that told the judge that this isn't about punishing mom so much as it's about making sure that our son actually has healthy teeth. It's not, you're a bad mom for not brushing his teeth. And of course, I mean, that's something that everyone's going to say, yeah, that's obvious. But more so, it's this child needs good teeth, and if you're having a lot of time with them, that's not going to happen. So I still have to say that had this been the only problem, the court might have been inclined to give her some kind of warning. The court might have been inclined to say, you know, I'm going to order ABC by X, Y, and Z, and if you don't do that, I'm going to modify custody. But I'm going to go into some of the other things that the court found that basically demonstrated to the court that this was something that was going to continue to happen. So let me just go into those things right now. So we're done with the dental neglect. We're going to look into the problem with failure to cooperate to meet the needs of the child. So what I did here is I focused on my ex's active steps to prevent the surgery from happening. So she took multiple. Now, this is critical. A lot of parents are neglectful or lazy, so they won't be involved. When a child needs like dentist or like a vision appointment or something, you'll usually have, when there's something going on, you usually have a parent who's just not involved. In my case, I had a parent who was actively taking steps to frustrate the process, and this was very, very different. I don't think the court had seen this before, and that was one of the reasons the court was so furious. So here's I think it was 3 things that my ex did to try to foil the surgery. The first thing she did was she set the surgery herself with the doctor, and when when they tried to do the surgery, she insisted on being in the appointment. She insisted on being in the operating room, and the dentist had to abort the procedure because she was being so obstinate. So it was basically a situation where she said, I'm not letting you do the surgery unless I'm in the operating room, which of course is unreasonable. But whatever. She did that, and that was the first thing that I showed the court. Is like, we had to set this to a second dentist because she caused the first one to abort the procedure and refuse to accept us as a client. With the second one, she did a couple of things. So she showed up and she signed the contract agreeing to pay for half of the cost of the surgery. And what she did was she changed her mind later, saying that she decided unilaterally, that means she herself decided that the surgery was not necessary and that his teeth weren't hurting, but his gum was hurting for other reasons relating to a cold. And I said, well, you know, I don't think 5 crowns and 2 extractions has anything to do with gums or a cold. And of course she said, well, I'm not going to pay for it. So I think she thought that I was going to have to abandon it because I wouldn't have enough money. But I ended up getting the money together. Once I had the money together, she stopped going to subsequent appointments. And I think at this point she was leveraging for some kind of way to get out of having to pay for the surgery. Because she sort of had it in her mind that if she didn't agree to the surgery and I insisted on it, I would have to pay for the whole thing, which is, of course, it's wrong. But that wasn't it. Then when I set the surgery appointment up, he needed to get a pre-op from his doctor, his family doctor, and it had to be done within 24 hours or 48 hours, one of the two, of the surgery. Now, the problem was that the surgery was, it was either on the tail end of her visitation or on the first day of my visitation. I think it was the first day of my visitation. And because she had the previous 2 or 3 days, she had to take him to the pre-op because it couldn't be sooner than 48 hours. It had to be within that 48-hour window. So I knew this was going to be an issue, but I tried it out. I sent her an email saying the pre-op has to be done on one of these 2 days, which are on your schedule. But if you don't want to take him, then just let me know and I'll go get him from school and I'll take him. Her response was, not only am I not going to take him, but that's my visitation time. You can't take him to that pre-op. And then my reply was, this isn't about really visitation time. This is about getting him the surgery he needs. If he doesn't get this pre-op, it's going to frustrate the surgery. They literally can't do the surgery unless the pre-op is done. And her response to that was, he's in tutoring, so he can't go. Which is, I mean, he was in tutoring on one of the days. He could have gone on the other day. So, I mean, I think I've talked about this before in other videos. Typically, abusive or manipulative parents will use something called pretexting. They won't say, you can't take my son to this because I'm a bad mom. They'll say something. They'll come up with some kind of, it's a BS excuse, but it's a pretext. It's something that they can kind of cloak their true intentions behind. So she was like, he's got his tutoring that day. You can't take him. And I said, well, I'm just going to take him because he needs to have the surgery. He's in pain. He was in pain. He was in serious pain. So I went to the school to take him to the surgery, and she drove there and went into the principal's office and rose this huge stink. So this is what I mean by this isn't a parent who's just checking out. This is a parent who's taking active steps, who's actually, it's like an obsession to interfere, to frustrate the best interest of the child. And that's something that I don't think people understand about inability to meet the needs, inability of the parents to cooperate to meet the needs of the child. It's not just, oh, we bicker and argue and it's stupid and I should get custody. It's, we bicker and argue and it's completely their fault, and this is causing harm. That second piece, you have to show that the bickering, the arguing, and the blame are contributing to harm to the child. That last piece is what's often missing. And the courts don't care if you bicker and argue amongst yourselves. If the kid's being taken care of, then that kid's being taken care of. And they're just going to allow you guys to share joint physical custody and yell at each other all you want. This is where I was able to show that this was actually causing a problem. And then, of course, the level of conflict between the parents, subsection D, that kind of contributes a little bit to that. It shows that the level of conflict is so high between us, and it's all one-sided, which the judge did say. The judge said there's a level of conflict that's extraordinarily high here, and it's entirely mom's fault. Those were in the findings of fact, and that was used to modify physical custody. And this was a big part of it. There's a little bit more behind the level of conflict, and I think I mentioned, so there's the midnight exchanges, which I'm going to talk about now, and then I'll talk about the medical appointment issues, and a little bit on the emails back and forth. So the midnight exchanges, this is something that I stipulated to early on, right away in 2008, because I was getting so much time with my son, I was getting joint physical custody. My ex was asking to be able to exchange our son at midnight temporarily. But now, of course, I was getting so much that I said, okay, that's fine, we'll just do that temporarily. You get off at work at midnight. She said she was going to change her schedule quickly, and then we would be able to move forward. Well, she lied. Number one, it wasn't in the order saying that it was temporary. Nothing was in the order saying it had anything to do with her work. The visitation schedule simply said from this time to midnight. So I couldn't rely on that later. I couldn't hold her to that and say, Your Honor, she said she was going to change this, because it wasn't in the written order. This is one of the things I've talked about. If it's not in the order, it doesn't count. It doesn't matter if the judge made an oral pronouncement from the bench. It doesn't matter if somebody said it in court. It has to be in the order, and it wasn't in there. The other thing was that, there was another issue with the midnight exchange now. I think I covered everything on it. It was twice. At that time, we didn't have half week, and we didn't have half week and half week right away. It was like a double exchange every week. I would pick him up Wednesday, drop him off Thursday, pick him up Friday. It was 2 times a week that we had to do the midnight exchanges. I can't recall now. So later on, I tried to modify it. I tried to modify that midnight exchange because it was bad for our son to have to get exchanged at midnight. That's when he should be asleep, obviously. And I couldn't modify it because the judge, her lawyer, used the doctrine of res judicata, which I believe I covered in one of my videos, which states that you can't modify something in an order unless you can show that there are changed circumstances. I tried to modify it a second time and failed on the same reasoning. And then I tried to modify it a third time, and I succeeded this time because I was able to argue that he was going to school, and so because our son was going to school, that is a changed circumstance, and the court modified the midnight exchange that was during the school week, but not the one that occurred during the weekend. So we still had to do that one. Um, anyway, when it came to the hearing on modifying physical custody, the judge totally used that against her. And here's what's funny is parents who want to play the law to hurt you and your kids don't understand that the law isn't always favorable to them in all situations. Sure, the law is favorable to her under the modification of custody principles, because I have to show changed circumstances. I mean, sorry, under the modification of an order, because I have to show changed circumstances. And sure, the law is going to be in her favor if I try to order to show cause her, which is to hold her in contempt of court, because I have to show that she's violating an order, and she's not. And these two things kind of had her pumped up, like I'm going to mess with you and your son because I can, because you can't get around these two legal doctrines, and ha ha. Well, the modification of physical custody and the best interest factors are disfavorable to her, and she didn't think that far ahead. Abusive people just think in their little sphere. They don't really think long term. They don't think outside the box. And so when that hearing came and the judge asked her, why are you doing these midnight exchanges? She said, well, the order said I could. And the judge was so pissed off. She said, why'd you ask for that order? And then she really didn't have a good answer for it. She said, well, I was doing this and this. And she just kept trying to fall back on the fact that it was legal and the other judge let her do that. And this judge was like, no, you kind of forced him to do that. And I just remember the judge really, it got to her. It really pissed her off. And she absolutely used the midnight exchanges that she insisted on against her. And that, I think, was the biggest reason why the judge did not give her a warning regarding the dental neglect. She saw the dental neglect and the damage it was causing. And she saw that this was a mom who was so bent on harming the other parent that she was willing to have her son exchanged at midnight 104 times a year, twice a week, for 6 years, 5 or 6 years. That really got to the judge, and she was convinced that this was not something that was ever going to be fixed through some kind of behavioral order. The next couple of things I was going to talk about was the 14 absences. So the judge stopped short of making a finding of educational neglect on my ex, but she still used the fact that she had been failing to take our son to school because I had previously brought to the court's attention the fact that I wanted her to take him to school, because this came up previously. She hadn't taken him to school 10 times in a row, and it was about to cause him expulsion. So the judge said, I think her exact words were, you're tone deaf on this issue because we've told you before it was a problem, and here you are still doing it, not taking him to school. So she used that against him in the sense of a failure to meet the physical, developmental, and emotional needs of the child, because obviously education is a developmental need. The last thing I was going to talk about, oh no, there's two more things. The repetitive medical appointment issues. So, if you can't tell, I have a cold, but anyway, the repetitive medical appointment issues. Okay, so what this had to do with was my ex was not allowing me to show up at medical appointments, vision appointments, dental appointments. There was two ways she did this. The first way was she wouldn't give me his benefits cards, and the second way was she would schedule appointments and not tell me. So what I did was, when I found out this was going on, I filed a motion right away asking the court to order her to turn over the cards and to tell me when appointments were. I got an order in the mail on that one. I didn't even have a hearing. The judge just flat out sent an order in the mail saying, tell him when the appointments are from now on, and give him the benefits cards. So what she decided to do was tell me when the appointments were a day or two before. She scheduled an appointment like 1 or 2 days and gave me like 1 or 2 days notice, and I showed up, and so next time she scheduled and gave me like 11 hours notice. It was a game. It was like, okay, I have to tell you, but I don't have to tell you in a convenient time. So she would schedule it on my work day, and she'd give me like less than a day's notice. So what did I do? I filed another motion saying I want 14 days notice. Now, in hindsight, I should have probably considered modifying physical custody back then on that second motion because it showed how willing she was to play games. But at the time, I didn't know that I could do that. So I filed a second motion, and this time the judge said, you need to give him 14 days notice. And at that point, a few times she gave me my 14 days notice, but there was sometimes when she would use emergencies, so-called emergencies. She would say, I don't remember, but she used some emergency situations to schedule appointments and stuff. And so anyway, when I came back to court on my motion to modify custody, and I want this to be clear to people, it wasn't so much, I mean, it was a big deal that she was frustrating my rights to go to the appointments. But what really got under the judge's skin was the fact that I had filed those previous motions. So the judge really connected more on that because she said, you know, he's filing motions not once, not twice, but 3 times. And you're still doing this even after you've been brought back to court 3 times on it. So this is one of the reasons I emphasize going to court when you're representing yourself. You don't have an attorney. You can take care of these little things by yourself. Your ex isn't telling you, you know, when these appointments are. That's something small. You can take care of that. I want to file a motion to get the benefits cards, and I want to file a motion to set a procedure for setting these appointments. And I did that, and those were so easy to do. It was like such a non-issue to get that relief, aside from having to wait months for the court to actually enter an order. But that was really taken into consideration by the court when I modified custody. She cited that in the order. The last thing was the emails back and forth, and this is one of the hardest things, I think, for a lot of people to really get their head around. I'm almost done. So close. It's still recording. They're going to see this. Sorry, guys. So, what was I going to say? Right, the emails back and forth. Towards the beginning, judges are going to be more understanding if you are bickering and fighting with your ex, and they're going to pretty much, they're not even going to want to read your emails because they're almost always the same in all situations. People just calling each other names, sniping each other, passive aggressiveness, blah, blah, blah. Anyway, in my case, this is like into year 6 or year 5 of my high conflict child custody case, and I had really gotten my communications down to a science. I was methodical. I was dispassionate. I was I was gray rock. It's a technique. You basically take all of the emotion out, and my emails were short, factual, and to the point. And when she would bait me, when she would say, you know, she would snipe remarks, I would not engage ever. And by this point, my emails were really clean and really, sterile. And so the court noticed that. When it looked at the emails communications at that time, it saw that all of hers were the ones that were loaded with, argumentative content, calling me names, stuff like that. And mine were just, I wasn't doing that. I know for some people it's hard to do this because you just get so mad, but really it helps your case so much. And the judge took that into consideration in my case. She took a look at those emails, and she said in her orders, I think her exact words were that I was basically placating her. When I wasn't arguing with her, I was placating her because I saw that there was no point to arguing with her. And the judge put that in the order. She counted that to my credit. And anyway, all of what I just mentioned to you was factored in, and based on all of those findings of fact, the court modified physical custody. I'm sorry that I can't give you a magical formula to tell you what'll work in your case, but I hope you can draw some kind of connections, some kind of analogies to how I did it, and I hope that you can use that to sort of get your head in the right place. You definitely think about watching this video a few times to pick up every little detail, because I tried to bring up everything that was important and relevant. For what it's worth, I did hire an attorney for the hearing on modification of child custody. I did all the motion practice myself, though. So that's all the papers, the pleadings, the motion, the reply, filing the request, and all that. The subpoenas, I did all that. And then I just got an attorney to come in and argue orally, which is, that's one of the things that attorneys can be really good at. I ended up having to get one of the best attorneys because a lot of attorneys don't actually do that. A lot of attorneys settle. They're negotiators. If you're going to go into battle, you should find an attorney who's got experience, go into trial, questioning witnesses, and battling. And that's it was an expensive attorney, but it was worth the money because I succeeded in the end, and custody was modified. Physical custody was modified. So if you have any questions, I'm not going to post the order or my motions, but if you really are curious about what the order looks like, if you want to know what the motion practice looked like, send me an email and I'll consider that. I'm not absolutely gung-ho about it right now, but I might change my mind. I mean, there's nothing in the order that's negative against me. The only thing I'm worried about is people copying and pasting my points and authorities and thinking that they're going to work in their case, and people need to understand you need to do your own research. That's why I'm so hesitant to just say, here's my motion, copy it. So with that, I'll stop this video, and I'll look forward to seeing you guys next time.